Procedure in regional trial courts. Rule 6. Kinds of pleadings. Section 1. Pleadings defined. Pleadings are the written statements of the respective claims and defenses of the parties submitted to the court for appropriate judgment. 1. Section 2. Pleadings allowed. The claims of a party are asserted in a complaint, counterclaim, cross-claim, third, fourth, etc. Party complaint, or complaint in intervention. The defenses of a party are alleged in the answer to the pleading asserting a claim against him or her. An answer may be responded to by a reply only if the defending party attaches an actionable document to the answer. 2a. Section 3. Complaint. The complaint is the pleading alleging the plaintiff's or claiming party's cause or causes of action. The names and residences of the plaintiff and defendant must be stated in the complaint. 3a. Section 4. Answer. An answer is a pleading in which a defending party sets forth his or her defenses. 4a. Section 5. Defenses. Defenses may either be negative or affirmative. A negative defense is the specific denial of the material fact or facts alleged in the pleading of the claimant essential to his or her cause or causes of action. An affirmative defense is an allegation of a new matter which, while hypothetically admitting the material allegations in the pleading of the claimant, would nevertheless prevent or bar recovery by him or her. The affirmative defenses include fraud, statute of limitations, release, payment, illegality, statute of frauds, estoppel, former recovery, discharge in bankruptcy, and any other matter by way of confession and avoidance. FSRPISEFRDCA. Affirmative defenses may also include grounds for the dismissal of a complaint, specifically that the court has no jurisdiction over the subject matter, that there is another action pending between the same parties for the same cause, or that the action is barred by a prior judgment. 5a.
Section 6. Counterclaim. A counterclaim is any claim which a defending party may have against an opposing party. 6. Section 7. Compulsory counterclaim. A compulsory counterclaim is one which, being cognizable by the regular courts of justice, arises out of or is connected with the transaction or occurrence constituting subject matter of the opposing party's claim and does not require for its adjudication the presence of third parties of whom the court cannot acquire jurisdiction. Such a counterclaim must be within the jurisdiction of the court both as to the amount and the nature thereof, except that in an original action before the regional trial court, the counterclaim may be considered compulsory regardless of the amount. A compulsory counterclaim not raised in the same action is barred, unless otherwise allowed by these rules. 7a. Section 8. Cross-claim. A cross-claim is any claim by one party against a co-party arising out of the transaction or occurrence that is the subject matter either of the original action or of a counterclaim therein. Such cross-claim may cover all or part of the original claim. 8a. Section 9. Counterclaims and counter-cross-claims. A counterclaim may be asserted against an original counterclaimant. A cross-claim may also be filed against an original cross-claimant. 9. Section 10. Reply. All new matters alleged in the answer are deemed contracto verdict. If the plaintiff wishes to interpose any claims arising out of the new matters so alleged, such claims shall be set forth in an amended or supplemental complaint. However, the plaintiff may file a reply only if the defending party attaches an actionable document to his or her answer. A reply is a pleading, the office or function of which is to deny, or allege facts in denial or avoidance of new matters alleged in, or relating to, said actionable document. In the event of an actionable document attached to the reply, the defendant may file a rejoinder if the same is based solely on an actionable document. 10a.
Section 11. Third, fourth, etc. Party complaint. A third, fourth, etc. Party complaint is a claim that a defending party may, with leave of court, file against a person not a party to the action, called the third, fourth, etc. Party defendant, for contribution, indemnity, subrogation, or any other relief, in respect of his or her opponent's claim. The third, fourth, etc. Party complaint shall be denied admission, and the court shall require the defendant to institute a separate action, where, a. the third, fourth, etc. Party defendant cannot be located within 30 calendar days from the grant of such leave, b. matters extraneous to the issue in the principal case are raised, or, c. the effect would be to introduce a new and separate controversy into the action. 11a. Section 12. Bringing new parties. When the presence of parties other than those to the original action is required for the granting of complete relief in the determination of a counterclaim or cross-claim, the court shall order them to be brought in as defendants, if jurisdiction over them can be obtained. 12. Section 13. Answer to third, fourth, etc. Party complaint. A third, fourth, etc. Party defendant may allege in his or her answer his or her defenses, counterclaims or cross-claims, including such defenses that the third, fourth, etc. party plaintiff may have against the original plaintiff's claim. In proper cases, he or she may also assert a counterclaim against the original plaintiff in respect of the latter's claim against the third-party plaintiff. 13a. This application will let you trade all assets in the market today, which include stocks, crypto, ETFs, indices, forex, commodities, among others. You can also copy the trades of the best traders, which is called social trading or copy trading. Earn rewards. Start by using my affiliate link. I may earn commissions from your registration. Rule 7. Parts and contents of a pleading. Section 1. Caption. The caption sets forth the name of the court, the title of the action, and the docket number if assigned. The title of the action indicates the names of the parties. They shall all be named in the original complaint or petition, but in subsequent pleadings, it shall be sufficient if the name of the first party on each side be stated with an appropriate indication when there are other parties. Their respective participation in the case shall be indicated. 1. Section 2. The body. The body of the pleading sets forth its designation, the allegations of the parties' claims or defenses, the relief prayed for, and the date of the pleading. Paragraphs. The allegations in the body of a pleading shall be divided into paragraphs so numbered as to be readily identified, each of which shall contain a statement of a single set of circumstances so far as that can be done with convenience. A paragraph may be referred to by its number in all succeeding pleadings. Headings. When two or more causes of action are joined, the statement of the first shall be prefaced by the words "first cause of action," of the second by "second cause of action," and so on for the others. When one or more paragraphs in the answer are addressed to one of several causes of action in the complaint, they shall be prefaced by the words "answer to the first cause of action" or "answer to the second cause of action," and so on, and when one or more paragraphs of the answer are addressed to several causes of action, they shall be prefaced by words to that effect. Relief. The pleading shall specify the relief sought, but it may add a general prayer for such further or other relief as may be deemed just or equitable. Date. Every pleading shall be dated. 4. Section 3. Signature and address. A. Every pleading and other written submissions to the court must be signed by the party or counsel representing him or her. B. The signature of counsel constitutes a certificate by him or her that he or she has read the pleading and document, that to the best of his or her knowledge, information, and belief formed after an inquiry reasonable under the circumstances, it is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. The claims, defenses, and other legal contentions are warranted by existing law or jurisprudence, or by a non-frivolous argument for extending, modifying, or reversing existing jurisprudence. The factual contentions have evidentiary support or, if specifically so identified, will likely have evidentiary support after availment of the modes of discovery under these rules, and the denials of factual contentions are warranted on the evidence or, if specifically so identified, are reasonably based on belief or a lack of information. C. If the court determines, on motion or motu proprio and after notice and hearing, that this rule has been violated, it may impose an appropriate sanction or refer such violation to the proper office for disciplinary action, on any attorney, law firm, or party that violated the rule, or is responsible for the violation. Absent exceptional circumstances, a law firm shall be held jointly and severally liable for a violation committed by its partner, associate, or employee. The sanction may include, but shall not be limited to, non-monetary directive or sanction, an order to pay a penalty in court, or, if imposed on motion and warranted for effective deterrence, an order directing payment to the movant of part or all of the reasonable attorney's fees and other expenses directly resulting from the violation, including attorney's fees for the filing of the motion for sanction. The lawyer or law firm cannot pass on the monetary penalty to the client. 3a. Section 4. Verification. Except when otherwise specifically required by law or rule, pleadings need not be under oath or verified. A pleading is verified by an affidavit of an affiant duly authorized to sign said verification. The authorization of the affiant to act on behalf of a party, whether in the form of a secretary's certificate or a special power of attorney, should be attached to the pleading, and shall allege the following attestations. The allegations in the pleading are true and correct based on his or her personal knowledge or based on authentic documents. The pleading is not filed to harass, cause unnecessary delay, or needlessly increase the cost of litigation, and the factual allegations therein have evidentiary support or, if specifically so identified, will likewise have evidentiary support after a reasonable opportunity for discovery. The signature of the affiant shall further serve as a certification of the truthfulness of the allegations in the pleading. A pleading required to be verified that contains a verification based on information and belief, or upon knowledge, information, and belief, or lacks a proper verification, shall be treated as an unsigned pleading. 4a. Section 5. Certification against forum shopping. The plaintiff or principal party shall certify under oath in the complaint or other initiatory pleading asserting a claim for relief, or in a sworn certification annexed thereto and simultaneously filed therewith, a. that he or she has not theretofore commenced any action or filed any claim involving the same issues in any court, tribunal, or quasi-judicial agency and, to the best of his or her knowledge, no such other action or claim is pending therein, b. if there is such other pending action or claim, a complete statement of the present status thereof, and, c. if he or she should thereafter learn that the same or similar action or claim has been filed or is pending, he or she shall report that fact within 5 calendar days therefrom to the court wherein his or her aforesaid complaint or initiatory pleading has been filed. The authorization of the affiant to act on behalf of a party, whether in the form of a secretary's certificate or a special power of attorney, should be attached to the pleading. Try Finviz app, the most comprehensive source of stock market information for United States stocks. Try it using the link in the description to get special offers. Get ahead of the pack now. Failure to comply with the foregoing requirements shall not be curable by mere amendment of the complaint or other initiatory pleading but shall be cause for the dismissal of the case without prejudice, unless otherwise provided, upon motion and after hearing. The submission of a false certification or non-compliance with any of the undertakings therein shall constitute indirect contempt of court, without prejudice to the corresponding administrative and criminal actions. If the acts of the party or his or her counsel clearly constitute willful and deliberate forum shopping, the same shall be ground for summary dismissal with prejudice and shall constitute direct contempt, as well as a cause for administrative sanctions. 5a. Section 6. Contents. Every pleading stating a party's claims or defenses shall, in addition to those mandated by Section 2, Rule 7, state the following. Names of witnesses who will be presented to prove a party's claim or defense. Summary of the witnesses' intended testimonies, provided that the judicial affidavits of said witnesses shall be attached to the pleading and form an integral part thereof. Only witnesses whose judicial affidavits are attached to the pleading shall be presented by the parties during trial. Except if a party presents meritorious reasons as basis for the admission of additional witnesses, no other witness or affidavit shall be heard or admitted by the court, and documentary and object evidence in support of the allegations contained in the pleading. N. Rule 8. Manner of making allegations in pleadings. Section 1. In general, every pleading shall contain in a methodical and logical form, a plain, concise and direct statement of the ultimate facts, including the evidence on which the party pleading relies for his or her claim or defense, as the case may be. If a cause of action or defense relied on is based on law, the pertinent provisions thereof and their applicability to him or her shall be clearly and concisely stated. 1a. Section 2. Alternative causes of action or defenses. A party may set forth two or more statements of a claim or defense alternatively or hypothetically, either in one cause of action or defense or in separate causes of action or defenses. When two or more statements are made in the alternative and one of them if made independently would be sufficient, the pleading is not made insufficient by the insufficiency of one or more of the alternative statements. 2. Section 3. Conditions precedent. In any pleading, a general averment of the performance or occurrence of all conditions precedent shall be sufficient. 3. Section 4. Capacity. Facts showing the capacity of a party to sue or be sued or the authority of a party to sue or be sued in a representative capacity or the legal existence of an organized association of persons that is made a party, must be averred. A party desiring to raise an issue as to the legal existence of any party or the capacity of any party to sue or be sued in a representative capacity, shall do so by specific denial, which shall include such supporting particulars as are peculiarly within the pleader's knowledge. 4. Section 5. Fraud, mistake, condition of the mind. In all averments of fraud or mistake, the circumstances constituting fraud or mistake must be stated with particularity. Malice, intent, knowledge, or other condition of the mind of a person may be averred generally. 5. Section 6. Judgment. In pleading a judgment or decision of a domestic or foreign court, judicial or quasi-judicial tribunal, or of a board or officer, it is sufficient to aver the judgment or decision without setting forth matter showing jurisdiction to render it. An authenticated copy of the judgment or decision shall be attached to the pleading. 6a. Section 7. Action or defense based on document. Whenever an action or defense is based upon a written instrument or document, the substance of such instrument or document shall be set forth in the pleading, and the original or a copy thereof shall be attached to the pleading as an exhibit, which shall be deemed to be a part of the pleading. 7a. Section 8. How to contest such documents. When an action or defense is founded upon a written instrument, or attached to the corresponding pleading as provided in the preceding section, the genuineness and due execution of the instrument shall be deemed admitted unless the adverse party, under oath, specifically denies them, and sets forth what he or she claims to be the facts, but the requirement of an oath does not apply when the adverse party does not appear to be a party to the instrument or when compliance with an order for an inspection of the original instrument is refused. 8a. Section 9. Official document or act. In pleading an official document or official act, it is sufficient to aver that the document was issued or the act was done in compliance with law. 9. Section 10. Specific denial. A defendant must specify each material allegation of fact the truth of which he or she does not admit and, whenever practicable, shall set forth the substance of the matters upon which he or she relies to support his or her denial. Where a defendant desires to deny only a part of an averment, he or she shall specify so much of it as is true and material and shall deny only the remainder. Where a defendant is without knowledge or information sufficient to form a belief as to the truth of a material averment made to the complaint, he or she shall so state, and this shall have the effect of a denial. 10a. Try Investigram's Go Prime Stock Screener. The number one source of business information for stock trading in the Philippines stock market. Get 5% discount by using my link. Section 11. Allegations not specifically denied deemed admitted. Material averments in a pleading asserting a claim or claims, other than those as to the amount of unliquidated damages, shall be deemed admitted when not specifically denied. 11a. Section 12. Affirmative defenses. A defendant shall raise his or her affirmative defenses in his or her answer, which shall be limited to the reasons set forth under Section 5, b, Rule 6, and the following grounds. That the court has no jurisdiction over the person of the defending party, JVCCC. That venue is improperly laid. That the plaintiff has no legal capacity to sue. That the pleading asserting the claim states no cause of action, and that a condition precedent for filing the claim has not been complied with. Failure to raise the affirmative defenses at the earliest opportunity shall constitute a waiver thereof. The court shall motu proprio resolve the above affirmative defenses within 30 calendar days from the filing of the answer. As to the other affirmative defenses under the first paragraph of Section 5b, Rule 6, the court may conduct a summary hearing within 15 calendar days from the filing of the answer. Such affirmative defenses shall be resolved by the court within 30 calendar days from the termination of the summary hearing. Affirmative defenses, if denied, shall not be the subject of a motion for reconsideration or petition for certiorari, prohibition, or mandamus, but may be among the matters to be raised on appeal after a judgment on the merits. N. Section 13. Striking out of pleading or matter contained therein. Upon motion made by a party before responding to a pleading or, if no responsive pleading is permitted by these rules, upon motion made by a party within 20 calendar days after the service of the pleading upon him or her, or upon the court's own initiative at any time, the court may order any pleading to be stricken out or that any sham or false, redundant, immaterial, impertinent, or scandalous matter be stricken out therefrom. 12a. Rule 9. Effect of failure to plead. Section 1. Defenses and objections not pleaded. Defenses and objections not pleaded either in a motion to dismiss or in the answer are deemed waived. However, when it appears from the pleadings or the evidence on record that the court has no jurisdiction over the subject matter, that there is another action pending between the same parties for the same cause, or that the action is barred by a prior judgment or by statute of limitations, the court shall dismiss the claim. 1. Section 2. Compulsory counterclaim, or cross-claim, not set up barred. A compulsory counterclaim, or a cross-claim, not set up shall be barred. 2. Section 3. Default, declaration of. If the defending party fails to answer within the time allowed therefor, the court shall, upon motion of the claiming party with notice to the defending party, and proof of such failure, declare the defending party in default. Thereupon, the court shall proceed to render judgment granting the claimant such relief as his or her pleading may warrant, unless the court in its discretion requires the claimant to submit evidence. Such reception of evidence may be delegated to the clerk of court. Effect of order of default. A party in default shall be entitled to notice of subsequent proceedings but shall not to take part in the trial. Relief from order of default. A party declared in default may at any time after notice thereof and before judgment, file a motion under oath to set aside the order of default upon proper showing that his or her failure to answer was due to fraud, accident, mistake, or excusable negligence and that he or she has a meritorious defense. In such case, the order of default may be set aside on such terms and conditions as the judge may impose in the interest of justice. Effect of partial default. When a pleading asserting a claim states a common cause of action against several defending parties, some of whom answer and the others fail to do so, the court shall try the case against all upon the answers thus filed and render judgment upon the evidence presented. Extent of relief to be awarded. A judgment rendered against a party in default shall neither exceed the amount or be different in kind from that prayed for nor award unliquidated damages. Where no defaults allowed. If the defending party in action for annulment or declaration of nullity of marriage or for legal separation fails to answer, the court shall order the Solicitor General or his or her deputized public prosecutor, to investigate whether or not a collusion between the parties exists, and if there is no collusion, to intervene for the state in order to see to it that the evidence submitted is not fabricated. 3a. Earn passive income from sales by promoting product links of Shopee, Lazada, Zalora among others. Just generate the affiliate link and post it in your social media. If someone buy, you will earn commission. Check out the link on the description to get rewards. Rule 10. Amended and Supplemental Pleadings. Section 1. Amendments in general. Pleadings may be amended by adding or striking out an allegation or the name of any party, or by correcting a mistake in the name of a party or a mistaken or inadequate allegation or description in any other respect, so that the actual merits of the controversy may speedily be determined, without regard to technicalities, in the most expeditious and inexpensive manner. 1a. Section 2. Amendments as a matter of right. A party may amend his or her pleading once as a matter of right at any time before a responsive pleading is served or, in the case of a reply, at any time within 10 calendar days after it is served. 2a. Section 3. Amendments by leave of court. Except as provided in the next preceding section, substantial amendments may be made only upon leave of court. But such leave shall be refused if it appears to the court that the motion was made with intent to delay or confer jurisdiction on the court, or the pleading stated no cause of action from the beginning which could be amended. Orders of the court upon the matters provided in this section shall be made upon motion filed in court, and after notice to the adverse party, and an opportunity to be heard. 3a. Section 4. Formal amendments. A defect in the designation of the parties and other clearly clerical or typographical errors may be summarily corrected by the court at any stage of the action, at its initiative or on motion, provided no prejudice is caused thereby to the adverse party. 4. Section 5. No amendment necessary to conform to or authorize presentation of evidence. When issues not raised by the pleadings are tried with the express or implied consent of the parties, they shall be treated in all respects as if they had been raised in the pleadings. No amendment of such pleadings deemed amended is necessary to cause them to conform to the evidence. 5a. Section 6. Supplemental pleadings. Upon motion of a party, the court may, upon reasonable notice and upon such terms as are just, permit him or her to serve a supplemental pleading setting forth transactions, occurrences, or events which have happened since the date of the pleading sought to be supplemented. The adverse party may plead thereto within 10 calendar days from notice of the order admitting the supplemental pleading. 6a. Section 7. Filing of amended pleadings. When any pleading is amended, a new copy of the entire pleading, incorporating the amendments, which shall be indicated by appropriate marks, shall be filed. 7. Section 8. Effect of amended pleadings. An amended pleading supersedes the pleading that it amends. However, admissions in superseded pleadings may be offered in evidence against the pleader, and claims or defenses alleged therein not incorporated in the amended pleading shall be deemed waived. 8a. Rule 11. When to file responsive pleadings. Section 1. Answer to the complaint. The defendant shall file his or her answer to the complaint within 30 calendar days after service of summons, unless a different period is fixed by the court. 1a. Section 2. Answer of a defendant foreign private juridical entity. Where the defendant is a foreign private juridical entity and service of summons is made on the government official designated by law to receive the same, the answer shall be filed within 60 calendar days after receipt of summons by such entity. 2a. Section 3. Answer to amended complaint. When the plaintiff files an amended complaint as a right, the defendant shall answer the same within 30 calendar days after being served with a copy thereof. Where its filing is not a matter of right, the defendant shall answer the amended complaint within 15 calendar days from notice of the order admitting the same. An answer earlier filed may serve as the answer to the amended complaint if no new answer is filed. This rule shall apply to the answer to an amended counterclaim, amended cross-claim, amended third, fourth, etc. Party complaint, and amended complaint in intervention. 3a. Section 4. Answer to counterclaim or cross-claim. A counterclaim or cross-claim must be answered within 20 calendar days from service. 4a. Section 5. Answer to third, fourth, etc. Party complaint. The time to answer a third, fourth, etc. party complaint shall be governed by the same rule as the answer to the complaint. 5. Gcash is a domestic online application which is the best app to use when paying bills. You can also invest in the stock market using this app and an app to buy life insurance. Try it now. See the link in the description of this video to get 50 pesos cash rebate.
Section 6. Reply. A reply, if allowed under Section 10, Rule 6 hereof, may be filed within 15 calendar days from service of the pleading responded to. 6a. Section 7. Answer to supplemental complaint. A supplemental complaint may be answered within 20 calendar days from notice of the order admitting the same, unless a different period is fixed by the court. The answer to the complaint shall serve as the answer to the supplemental complaint if no new or supplemental answer is filed. 7a. Section 8. Existing counterclaim or cross-claim. A compulsory counterclaim or a cross-claim that a defending party has at the time he or she files his or her answer shall be contained therein. 8a. Section 9. Counterclaim or cross-claim arising after answer. A counterclaim or a cross-claim which either matured or was acquired by a party after serving his or her pleading may, with the permission of the court, be presented as a counterclaim or a cross-claim by supplemental pleading before judgment. 9a. Section 10. Omitted counterclaim or cross-claim. When a pleader fails to set up a counterclaim or a cross-claim through oversight, inadvertence, or excusable neglect, or when justice requires, he or she may, by leave of court, set up the counterclaim or cross-claim by amendment before judgment. 10a. Section 11. Extension of time to file an answer. A defendant may, for meritorious reasons, be granted an additional period of not more than 30 calendar days to file an answer. A defendant is only allowed to file one motion for extension of time to file an answer. A motion for extension to file any pleading, other than an answer, is prohibited and considered a mere scrap of paper. The court, however, may allow any other pleading to be filed after the time fixed by these rules. 11a. Rule 12. Bill of Particulars. Section 1. When applied for purpose. Before responding to a pleading, a party may move for a definite statement or for a bill of particulars of any matter, which is not averred with sufficient definiteness or particularity, to enable him or her properly to prepare his or her responsive pleading. If the pleading is a reply, the motion must be filed within 10 calendar days from service thereof. Such motion shall point out the defects complained of, the paragraphs wherein they are contained, and the details desired. 1a. Section 2. Action by the court. Upon the filing of the motion, the clerk of court must immediately bring it to the attention of the court, which may either deny or grant it outright, or allow the parties the opportunity to be heard. 2. Section 3. Compliance with order. If the motion is granted, either in whole or in part, the compliance therewith must be effected within 10 calendar days from notice of the order, unless a different period is fixed by the court. The bill of particulars or a more definite statement ordered by the court may be filed either in a separate or in an amended pleading, serving a copy thereof on the adverse party. 3a. Section 4. Effect of non-compliance. If the order is not obeyed, or in case of insufficient compliance therewith, the court may order the striking out of the pleading or the portions thereof to which the order was directed, or make such other order as it deems just. 4. Section 5. Stay of period to file responsive pleading. After service of the bill of particulars or of a more definite pleading, or after notice of denial of his or her motion, the moving party may file his or her responsive pleading within the period to which he or she was entitled at the time of filing his or her motion, which shall not be less than 5 calendar days in any event. 5a. Section 6. Bill of part of pleading. A bill of particulars becomes part of the pleading for which it is intended. 6.
Rule 13. Filing and service of pleadings, judgments and other papers. Section 1. Coverage. This rule shall govern the filing of all pleadings, motions, and other court submissions, as well as the service thereof, except those for which a different mode of service is prescribed. 1a. Section 2. Filing and service, defined. Filing is the act of submitting the pleading or other paper to the court. Service is the act of providing a party with a copy of the pleading or any other court submission. If a party has appeared by counsel, service upon such party shall be made upon his or her counsel, unless service upon the party and the party's counsel is ordered by the court. Where one counsel appears for several parties, such counsel shall only be entitled to one copy of any paper served upon him by the opposite side. Where several counsels appear for one party, such party shall be entitled to only one copy of any pleading or paper to be served upon the lead counsel if one is designated, or upon any one of them if there is no designation of a lead counsel. 2a. Section 3. Manner of filing. The filing of pleadings and other court submissions shall be made by submitting personally the original thereof, plainly indicated as such, to the court, PRAE. Sending them by registered mail. Sending them by accredited courier, or transmitting them by electronic mail or other electronic means as may be authorized by the court in places where the court is electronically equipped. In the first case, the clerk of court shall endorse on the pleading the date and hour of filing. In the second and third cases, the date of the mailing of motions, pleadings, and other court submissions, and payments or deposits, as shown by the post office stamp on the envelope or the registry receipt, shall be considered as the date of their filing, payment, or deposit in court. The envelope shall be attached to the record of the case. In the fourth case, the date of electronic transmission shall be considered as the date of filing. 3a.
Section 4. Papers required to be filed and served. Every judgment, resolution, order, pleading subsequent to the complaint, written motion, notice, appearance, demand, offer of judgment or similar papers shall be filed with the court, and served upon the parties affected. 4. Section 5. Modes of service. Pleadings, motions, notices, orders, judgments, and other court submissions shall be served personally or by registered mail, accredited courier, electronic mail, facsimile transmission, other electronic means as may be authorized by the CART, or as provided for in international conventions to which the Philippines is a party. 5a. Raptoire. Section 6. Personal service. Court submissions may be served by personal delivery of a copy to the party or to the party's counsel, 1, or 2, to their authorized representative named in the appropriate pleading or motion, or 3, by leaving it in his or her office with his or her clerk, or with a person having charge thereof. If no person is found in his or her office, or his or her office is not known, or he or she has no office, then by leaving the copy, between the hours of 8 in the morning and 6 in the evening, at the 4 parties or counsel's residence, if known, with a person of sufficient age and discretion residing therein. 6a. Section 7. Service by mail. Service by registered mail shall be made by depositing the copy in the post office, in a sealed envelope, plainly addressed to the party or to the party's counsel at his or her office, if known, otherwise at his or her residence, if known, with postage fully prepaid, and with instructions to the postmaster to return the mail to the sender after 10 calendar days if undelivered. If no registry service is available in the locality of either the sender or the addressee, service may be done by ordinary mail. 7a. Section 8. Substituted service. If service of pleadings, motions, notices, resolutions, orders and other papers cannot be made under the two preceding sections, the office and place of residence of the party or his or her counsel being unknown, service may be made by delivering the copy to the clerk of court, with proof of failure of both personal service and service by mail. The service is complete at the time of such delivery. 8a.
Gcash is a domestic online application which is the best app to use when paying bills. You can also invest in the stock market using this app and an app to buy life insurance. Try it now. See the link in the description of this video to get 50 pesos cash rebate.
Section 9. Service by electronic means and facsimile. Service by electronic means and facsimile shall be made if the party concerned consents to such modes of service. Service by electronic means shall be made by sending an email to the parties or counsel's electronic mail address, or through other electronic means of transmission as the parties may agree on, or upon direction of the court. Service by facsimile shall be made by sending a facsimile copy to the parties or counsel's given facsimile number. N. Section 10. Presumptive service. There shall be presumptive notice to a party of a court setting if such notice appears on the records to have been mailed at least 20 calendar days prior to the scheduled date of hearing, and if the addressee is from within the same judicial region of the court where the case is pending, or at least 30 calendar days if the addressee is from outside the judicial region. N. Section 11. Change of electronic mail address or facsimile number. A party who changes his or her electronic mail address or facsimile number while the action is pending must promptly file, within 5 calendar days from such change, a notice of change of email address or facsimile number with the court and serve the notice on all other parties. Service through the electronic mail address or facsimile number of a party shall be presumed valid unless such party notifies the court of any change, as aforementioned. N. Section 12. Electronic mail and facsimile subject and title of pleadings and other documents. The subject of the electronic mail and facsimile must follow the prescribed format, case number, case title, and the pleading, order or document title. The title of each electronically filed or served pleading or other document, and each submission served by facsimile shall contain sufficient information to enable the court to ascertain from the title, a. the party or parties filing or serving the paper, b. nature of the paper, c. the party or parties against whom relief, if any, is sought, and d. the nature of the relief sought. N. Section 13. Service of judgments, final orders or resolutions. Judgments, final orders, or resolutions shall be served either personally or by registered mail. Upon ex parte motion of any party in the case, a copy of the judgment, final order. Section 5. Effect of reversal of executed judgment. Where the executed judgment is reversed totally or partially, or annulled, on appeal or otherwise, the trial court may, on motion, issue such orders of restitution or reparation of damages as equity and justice may warrant under the circumstances. 5a. Section 6. Execution by motion or by independent action. A final and executory judgment or order may be executed on motion within 5 years from the date of its entry. After the lapse of such time, and before it is barred by the statute of limitations, a judgment may be enforced by action. The revived judgment may also be enforced by motion within 5 years from the date of its entry and thereafter by action before it is barred by the statute of limitations. 6a. Section 7. Execution in case of death of party. In case of the death of a party, execution may issue or be enforced in the following manner. In case of the death of the judgment obligee, upon the application of his executor or administrator, or successor in interest. In case of the death of the judgment obliger, against his executor or administrator or successor in interest, if the judgment be for the recovery of real or personal property, or the enforcement of a lien thereon. In case of the death of the judgment obliger, after execution is actually levied upon any of his property, the same may be sold for the satisfaction of the judgment obligation, and the officer making the sale shall account to the corresponding executor or administrator for any surplus in his hands. 7a. Section 8. Issuance, form, and contents of a writ of execution. The writ of execution shall, 1. Issue in the name of the Republic of the Philippines from the court which granted the motion, 2. State the name of the court, the case number and title, the dispositive part of the subject judgment or order, and 3. Require the sheriff or other proper officer to whom it is directed to enforce the writ according to its terms, in the manner hereinafter provided. If the execution be against the property of the judgment obliger, to satisfy the judgment, with interest, out of the real or personal property of such judgment obliger. if it be against real or personal property in the hands of personal representatives, heirs, devises, legatees, tenants, or trustees of the judgment obliger, to satisfy the judgment, with interest, out of such property. If it be for the sale of real or personal property, to sell such property describing it, and apply the proceeds in conformity with the judgment, the material parts of which shall be recited in the writ of execution. If it be for the delivery of the possession of real or personal property, to deliver the possession of the same, describing it, to the party entitled thereto, and to satisfy any costs, damages, rents, or profits covered by the judgment out of the personal property of the person against whom it was rendered, and if sufficient personal property cannot be found, then out of the real property, and in all cases, the writ of execution shall specifically state the amount of the interest, costs, damages, rents, or profits due as of the date of the issuance of the writ, aside from the principal obligation under the judgment. For this purpose, the motion for execution shall specify the amounts of the foregoing reliefs sought by the movant. 8a. Section 9. Execution of judgments for money, how enforced.
Immediate payment on demand. The officer shall enforce an execution of a judgment for money by demanding from the judgment obliger the immediate payment of the full amount stated in the writ of execution and all lawful fees. The judgment obliger shall pay in cash, certified bank check payable to the judgment obligee, or any other form of payment acceptable to the latter, the amount of the judgment debt under proper receipt directly to the judgment obligee or his authorized representative if present at the time of payment. The lawful fees shall be handed under proper receipt to the executing sheriff, who shall turn over the said amount within the same day to the clerk of court of the court that issued the writ. If the judgment obligee or his authorized representative is not present to receive payment, the judgment obliger shall deliver the aforesaid payment to the executing sheriff. The latter shall turn over all the amounts coming into his possession within the same day to the clerk of court that issued the writ, or if the same is not practicable, deposit said amounts to a fiduciary account in the nearest government depository bank of the regional trial court of the locality. The clerk of said court shall thereafter arrange for the remittance of the deposit to the account of the court that issued the writ, whose clerk of court shall then deliver said payment to the judgment obligee in satisfaction of the judgment. The excess, if any, shall be delivered to the judgment obliger, while the lawful fees shall be retained by the clerk of court for disposition as provided by law. In no case shall the executing sheriff demand that any payment by check be made payable to him. Satisfaction by levy. If the judgment obliger cannot pay all or part of the obligation in cash, certified bank check, or other mode of payment acceptable to the judgment obligee, the officer shall levy upon the properties of the judgment obliger of every kind and nature whatsoever which may be disposed of for value and not otherwise exempt from execution, giving the latter the option to immediately choose which property or part thereof may be
levied upon, sufficient to satisfy the judgment. If the judgment obliger does not exercise the option, the officer shall first levy on the personal properties, if any, and then on the real properties if the personal properties are insufficient to answer for the judgment. The sheriff shall sell only a sufficient portion of the personal or real property of the judgment obliger which has been levied upon. When there is more property of the judgment obliger than is sufficient to satisfy the judgment and lawful fees, he must sell only so much of the personal or real property as is sufficient to satisfy the judgment and lawful fees. Real property, stocks, shares, debts, credits, and other personal property, or any interest in either real or personal property, may be levied upon in like manner and with like effect as under a writ of attachment. C. Garnishment of debts and credits. The officer may levy on debts due the judgment obliger and other credits, including bank deposits, financial interests, royalties, commissions and other personal property not capable of manual delivery in the possession or control of third parties. Levy shall be made by serving notice upon the person owing such debts or having in his possession or control such credits to which the judgment obliger is entitled. The garnishment shall cover only such amount as will satisfy the judgment and all lawful fees. The garnishee shall make a written report to the court within 5 days from service of the notice of garnishment, stating whether or not the judgment obliger has sufficient funds or credits to satisfy the amount of the judgment. If not, the report shall state how much funds or credits the garnishee holds for the judgment obliger. The garnished amount in cash, or certified bank check issued in the name of the judgment obligee, shall be delivered directly to the judgment obligee within 10 working days from service of notice on said garnishee requiring such delivery, except the lawful fees which shall be paid directly to the court. In the event there are 2 or more garnishees holding deposits or credits sufficient to satisfy the judgment obliger, if available, shall have the right to indicate the garnishee or garnishees who shall be required to deliver the amount due, otherwise, the choice shall be made by the judgment obligee. The executing sheriff shall observe the same procedure under paragraph A, with respect to delivery of payment to the judgment obligee. 8a, 15a. Section 10. Execution of judgments for specific act. Conveyance, delivery of deeds, or other specific acts, vesting title. If a judgment directs a party to execute a conveyance of land or personal property, or to deliver deeds or other documents, or to perform any other specific act in connection therewith, and the party fails to comply within the time specified, the court may direct the act to be done at the cost of the disobedient party by some other person appointed by the court, and the act when so done shall have like effect as if done by the party. If real or personal property is situated within the Philippines, the court in lieu of directing a conveyance thereof may by an order divest the title of any party and vest it in others, which shall have the force and effect of a conveyance executed in due form of law. 10a. Sale of real or personal property. If the judgment be for the sale of real or personal property, to sell such property, describing it, and apply the proceeds in conformity with the judgment. 8ca. Delivery or restitution of real property. The officer shall demand of the person against whom the judgment for the delivery or restitution of real property is rendered, and all persons claiming rights under him, to peaceably vacate the property within 3 working days, and restore possession thereof to the judgment obligee, otherwise, the officer shall oust all such persons therefrom with the assistance, if necessary, of appropriate peace officers, and employing such means as may be reasonably necessary to retake possession, and place the judgment obligee in possession of such property. Any costs, damages, rents or profits awarded by the judgment shall be satisfied in the same manner as a judgment for money. 13a. Removal of improvements on property subject of execution. When the property subject of the execution contains improvements constructed or planted by the judgment obliger or his agent, the officer shall not destroy, demolish, or remove said improvements except upon special order of the court, issued upon motion of the judgment obligee after the hearing and after the former has failed to remove the same within a reasonable time fixed by the court. 14a. Delivery of personal property. In judgment for the delivery of personal property, the officer shall take possession of the same and forthwith deliver it to the party entitled thereto, and satisfy any judgment for money as therein provided. 8a. Section 11. Execution of special judgments. When a judgment requires the performance of any act other than those mentioned in the 2 preceding sections, a certified copy of the judgment shall be attached to the writ of execution and shall be served by the officer upon the party against whom the same is rendered, or upon any other person required thereby, or by law, to obey the same, and such party or person may be punished for contempt if he disobeys such judgment. 9a. Section 12. Effect of levy on execution as to third person. The levy on execution shall create a lien in favor of the judgment obligee over the right, title, and interest of the judgment obliger in such property at the time of the levy, subject to liens and encumbrances then existing. 16a. Section 13. Property exempt from execution. Except as otherwise expressly provided by law, the following property, and no other, shall be exempt from execution: the judgment obliger's family home as provided by law, or the homestead in which he resides, and land necessarily used in connection therewith. Ordinary tools and implements personally used by him in his trade, employment, or livelihood. 3 horses, or 3 cows, or 3 carabaos, or other beasts of burden, such as the judgment obliger may select necessarily used by him in his ordinary occupation. His necessary clothing and articles for ordinary personal use, excluding jewelry. Household furniture and utensils necessary for housekeeping, and used for that purpose by the judgment obliger and his family, such as the judgment obliger may select, of a value not exceeding 100,000 pesos. Provisions for individual or family use sufficient for 4 months. The professional libraries and equipment of judges, lawyers, physicians, pharmacists, dentists, engineers, surveyors, clergymen, teachers, and other professionals, not exceeding 300,000 pesos in value. 1 fishing boat and accessories not exceeding the total value of 100,000 pesos owned by a fisherman and by the lawful use of which he earns his livelihood. So much of the salaries, wages, or earnings of the judgment obliger for his personal services within the 4 months preceding the levy as are necessary for the support of his family. Lettered gravestones. Moneys, benefits, privileges, or annuities accruing or in any manner growing out of any life insurance. The right to receive legal support, or money, or property obtained as such support, or any pension or gratuity from the government. Properties specially exempted by law. But no article or species of property mentioned in this section shall be exempt from execution issued upon a judgment recovered for its price or upon a judgment of foreclosure of a mortgage thereon. 12a. Section 14. Return of writ of execution. The writ of execution shall be returnable to the court issuing it immediately after the judgment has been satisfied in part or in full. If the judgment cannot be satisfied in full within 30 days after his receipt of the writ, the officer shall report to the court and state the reason therefor. Such writ shall continue in effect during the period within which the judgment may be enforced by motion. The officer shall make a report to the court every 30 days on the proceedings taken thereon until the judgment is satisfied in full, or its effectivity expires. The returns or periodic reports shall set forth the whole of the proceedings taken, and shall be filed with the court and copies thereof. Promptly furnished the parties. 11a. Section 15. Notice of sale of property on execution. Before the sale of property on execution, notice thereof must be given as follows. In case of perishable property, by posting written notice of the time and place of the sale in 3 public places, preferably in conspicuous areas of the municipal or city hall, post office, and public market in the municipality or city where the sale is to take place, for such time as may be reasonable, considering the character and condition of the property. In case of other personal property, by posting a similar notice in the 3 public places above mentioned for not less than 5 days. In case of real property, by posting for 20 days in the 3 public places above mentioned a similar notice particularly describing the property and stating where the property is to be sold, and if the assessed value of the property exceeds 50,000, P50,000.00 pesos, by publishing a copy of the notice once a week for two consecutive weeks in one newspaper selected by raffle, whether in English, Filipino, or any major regional language published, edited and circulated or, in the absence thereof, having general circulation in the province or city. d. In all cases, written notice of the sale shall be given to the judgment obliger, at least 3 days before the sale, except as provided in paragraph a hereof, where notice shall be given the same manner as personal service of pleadings and other papers as provided by Section 6 of Rule 13. The notice shall specify the place, date, and exact time of the sale, which should not be earlier than 9 o'clock in the morning and not later than 2 o'clock in the afternoon. The place of the sale may be agreed upon by the parties. In the absence of such agreement, the sale of the property or personal property not capable of manual delivery shall be held in the office of the clerk of court of the regional trial court or the municipal trial court which issued the writ of or which was designated by the appellate court. In the case of personal property capable of manual delivery, the sale shall be held in the place where the property is located. 18a. Section 16. Proceedings where property claimed by third person. If the property levied on is claimed by any person other than the judgment obliger or his agent, and such person makes an affidavit of his title thereto or right to the possession thereof, stating the grounds of such right or title, and serves the same upon the officer making the levy and copy thereof, stating the grounds of such right or tittle, and serves the same upon the officer making the levy and a copy thereof upon the judgment obligee, the officer shall not be bound to keep the property, unless such judgment oblige, on demand of the officer, files a bond approved by the court to indemnity the third-party claimant in a sum not less than the value of the property levied on. In case of disagreement as to such value, the same shall be determined by the court issuing the writ of execution. No claim for damages for the taking or keeping of the property may be enforced against the bond unless the action therefore is filed within 120 days from the date of the filing of the bond. The officer shall not be liable for damages for the taking or keeping of the property, to any third-party claimant if such bond is filed. Nothing herein contained shall prevent such claimant or any third person from vindicating his claim to the property in a separate action, or prevent the judgment oblige from claiming damages in the same or a separate action against a third-party claimant who filed a frivolous or plainly spurious claim. When the writ of execution is issued in favor of the Republic of the Philippines, or any officer duly representing it, the filing of such bond shall not be required, and in case the sheriff or levying officer is sued for damages as a result of the levy, he shall be represented by the Solicitor General, and if held liable therefor, the actual damages adjudged by the court shall be paid by the National Treasurer out of such funds as may be appropriated for the purpose. 17a. Section 17. Penalty for selling without notice, or removing or defacing notice. An officer selling without the notice prescribed by Section 15 of this rule shall be liable to pay punitive damages in the amount of 5,000 P5,000.00 pesos to any person injured thereby, in addition to his actual damages, both to be recovered by motion in the same action, and a person willfully removing or defacing the notice posted, if done before the sale, or before the satisfaction of the judgment if it be satisfied before the sale, shall be liable to pay 5,000 P5,000.00 pesos to any person injured by reason thereof, in addition to his actual damages, to be recovered by motion in the same action. 19a. Section 18. No sale if judgment and costs paid. At any time before the sale of property on execution, the judgment obliger may prevent the sale by paying the amount required by the execution and the costs that have been incurred therein. 20a. Section 19. How property sold on execution, who may direct manner and order of sale. All sales of property under execution must be made at public auction, to the highest bidder, to start at the exact time fixed in the notice. After sufficient property has been sold to satisfy the execution, no more shall be sold, and any excess property or proceeds of the sale shall be promptly delivered to the judgment obliger or his authorized representative, unless otherwise directed by the judgment or order of the court. When the sale is of real property, consisting of several known lots, they must be sold separately, or when a portion of such real property is claimed by a third person, he may require it to be sold separately. When the sale is of personal property capable of manual delivery, it must be sold within view of those attending the same and in such parcels as are likely to bring the highest price. The judgment obliger, if present at the sale, may direct the order in which property, real or personal, shall be sold, when such property consists of several known lots or parcels which can be sold to advantage separately. Neither the officer conducting the execution sale, nor his deputies, can become a purchaser, nor be interested directly or indirectly in any purchase at such sale. 21a. Section 20. Refusal of purchaser to pay. If a purchaser refuses to pay the amount bid by him for property struck off to him at a sale under execution, the officer may again sell the property to the highest bidder and shall not be responsible for any loss occasioned thereby, but the court may order the refusing purchaser to pay into the court the amount of such loss, with costs, and may punish him for contempt if he disobeys the order. The amount of such payment shall be for the benefit of the person entitled to the proceeds of the execution, unless the execution has been fully satisfied, in which event such proceeds shall be for the benefit of the judgment obliger. The officer may thereafter reject any subsequent bid of such purchaser who refuses to pay. 22a. Section 21. Judgment obligee as purchaser. When the purchaser is the judgment obligee, and no third-party claim has been filed, he need not pay the amount of the bid if it does not exceed the amount of his judgment. If it does, he shall pay only the excess. 23a. Section 22. Adjournment of sale. By written consent of the judgment obliger and obligee, or their duly authorized representatives, the officer may adjourn the sale to any date and time agreed upon by them. Without such agreement, he may adjourn the sale from day to day if it becomes necessary to do so for lack of time to complete the sale on the day fixed in the notice or the day to which it was adjourned. 24a. Section 23. Conveyance to purchaser of personal property capable of manual delivery. When the purchaser of any personal property, capable of manual delivery, pays the purchase price, the officer making the sale must deliver the property to the purchaser and, if desired, execute and deliver to him a certificate of sale. The sale conveys to the purchaser all the rights which the judgment obliger had in such property as of the date of the levy on execution or preliminary attachment. 25a. Section 24. Conveyance to purchaser of personal property not capable of manual delivery. When the purchaser of any personal property, not capable of manual delivery, pays the purchase price, the officer making the sale must execute and deliver to the purchaser a certificate of sale. Such certificate conveys to the purchaser all the rights which the judgment obliger had in such property as of the date of the levy on execution or preliminary attachment. 26a. Section 25. Conveyance of real property, certificate thereof given to purchaser and filed with Registry of Deeds. Upon a sale of real property, the officer must give to the purchaser a certificate of sale containing a particular description of the real property sold, the price paid for each distinct lot or parcel, the whole price paid by him, a statement that the right of redemption expires 1 year from the date of the registration of the certificate of sale. Such certificate must be registered in the Registry of Deeds of the place where the property is situated. 27a. Section 26. Certificate of sale where property claimed by third person. When a property sold by virtue of a writ of execution has been claimed by a third person, the certificate of sale to be issued by the sheriff pursuant to sections 23, 24, and 25 of this rule shall make express mention of the existence of such third-party claim. 28a. Section 27. Who may redeem real property so sold. Real property sold as provided in the last preceding section, or any part thereof sold separately, may be redeemed in the manner hereinafter provided, by the following persons: the judgment obliger, or his successor in interest in the whole or any part of the property; a creditor having a lien by virtue of an attachment, judgment, or mortgage on the property sold, or on some part thereof, subsequent to the lien under which the property was sold. Such redeeming creditor is termed a redemptioner. 29a. Section 28. Time and manner of, and amounts payable on, successive redemptions, notice to be given and filed. The judgment obliger, or redemptioner, may redeem the property from the purchaser, at any time within 1 year from the date of the registration of the certificate of sale, by paying the purchaser the amount of his purchase, with the per centum per month interest thereon in addition, up to the time of redemption, together with the amount of any assessments or taxes which the purchaser may have paid thereon after purchase, and interest on such last named amount at the same rate, and if the purchaser be also a creditor having a prior lien to that of the redemptioner, other than the judgment under which such purchase was made, the amount of such other lien, with interest. Property so redeemed may again be redeemed within 60 days after the last redemption upon payment of the sum paid on the last redemption, with 2 per centum thereon in addition, and the amount of any assessments or taxes which the last redemptioner may have paid thereon after redemption by him, with interest on such last named amount, and in addition, the amount of any liens held by said last redemptioner prior to his own, with interest. The property may be again, and as often as a redemptioner is so disposed, redeemed from any previous redemptioner within 60 days after the last redemption, on paying the sum paid on the last previous redemption, with 2 per centum thereon in addition, and the amounts of any assessments or taxes which the last previous redemptioner paid after the redemption thereon, with interest thereon, and the amount of any liens held by the last redemptioner prior to his own, with interest. Written notice of any redemption must be given to the officer who made the sale and a duplicate filed with the Registry of Deeds of the place, and if any assessments or taxes are paid by the redemptioner, or if he has or acquires any lien other than that upon which the redemption was made, notice thereof must in like manner be given to the officer and filed with the registry of deeds. If such notice be not filed, the property may be redeemed without paying such assessments, taxes, or liens. 30a. Section 29. Effect of redemption by judgment obliger, and a certificate to be delivered and recorded thereupon, to whom payments on redemption made. If the judgment obliger redeems, he must make the same payments as are required to effect a redemption by a redemptioner, whereupon, no further redemption shall be allowed and he is restored to his estate. The person to whom the redemption payment is made must execute and deliver to him a certificate of redemption acknowledged before a notary public or other officer authorized to take acknowledgments of conveyances of real property. Such certificate must be filed and recorded in the registry of deeds of the place in which the property is situated, and the registrar of deeds must note the record thereof on the margin of the record of the certificate of sale. The payments mentioned in this and the last preceding sections may be made to the purchaser or redemptioner, or for him to the officer who made the sale. 31a. Section 30. Proof required of redemptioner. A redemptioner must produce to the officer, or person from whom he seeks to redeem, and serve with his notice to the officer a copy of the judgment or final order under which he claims the right to redeem, certified by the clerk of the court wherein the judgment or final order is entered, or, if he redeems upon a mortgage or other lien, a memorandum of the record thereof, certified by the registrar of deeds, or an original or certified copy of any assignment necessary to establish his claim, and an affidavit executed by him or his agent, showing the amount then actually due on the lien. 32a. Section 31. Manner of using premises pending redemption, waste restrained. Until the expiration of the time allowed for redemption, the court may, as in other proper cases, restrain the commission of waste on the property by injunction, on the application of the purchaser or the judgment obligee, with or without notice, but it is not waste for a person in possession of the property at the time of the sale, or entitled to possession afterwards, during the period allowed for redemption, to continue to use it in the same manner in which it was previously used, or to use it in the ordinary course of husbandry, or to make the necessary repairs to buildings thereon while he occupies the property. 33a. Section 32. Rents, earnings and income of property pending redemption. The purchaser or a redemptioner shall not be entitled to receive the rents, earnings and income of the property sold on execution, or the value of the use and occupation thereof when such property is in the possession of a tenant. All rents, earnings and income derived from the property pending redemption shall belong to the judgment obliger until the expiration of his period of redemption. 34a. Section 33. Deed and possession to be given at expiration of redemption period, by whom executed or given. If no redemption be made within 1 year from the date of the registration of the certificate of sale, the purchaser is entitled to a conveyance and possession of the property, or, if so redeemed whenever 60 days have elapsed and no other redemption has been made, and notice thereof given, and the time for redemption has expired, the last redemptioner is entitled to the conveyance and possession, but in all cases the judgment obliger shall have the entire period of 1 year. Section 30. Proof required of redemptioner. A redemptioner must produce to the officer, or person from whom he seeks to redeem, and serve with his notice to the officer a copy of the judgment or final order under which he claims the right to redeem, certified by the clerk of the court wherein the judgment or final order is entered, or, if he redeems upon a mortgage or other lien, a memorandum of the record thereof, certified by the registrar of deeds, or an original or certified copy of any assignment necessary to establish his claim, and an affidavit executed by him or his agent, showing the amount then actually due on the lien. 32a. Section 31. Manner of using premises pending redemption, waste restrained. Until the expiration of the time allowed for redemption, the court may, as in other proper cases, restrain the commission of waste on the property by injunction, on the application of the purchaser or the judgment obligee, with or without notice, but it is not waste for a person in possession of the property at the time of the sale, or entitled to possession afterwards, during the period allowed for redemption, to continue to use it in the same manner in which it was previously used, or to use it in the ordinary course of husbandry, or to make the necessary repairs to buildings thereon while he occupies the property. 33a. Section 32. Rents, earnings and income of property pending redemption. The purchaser or a redemptioner shall not be entitled to receive the rents, earnings and income of the property sold on execution, or the value of the use and occupation thereof when such property is in the possession of a tenant. All rents, earnings and income derived from the property pending redemption shall belong to the judgment obliger until the expiration of his period of redemption. 34a. Section 33. Deed and possession to be given at expiration of redemption period, by whom executed or given. If no redemption be made within 1 year from the date of the registration of the certificate of sale, the purchaser is entitled to a conveyance and possession of the property, or, if so redeemed whenever 60 days have elapsed and no other redemption has been made, and notice thereof given, and the time for redemption has expired, the last redemptioner is entitled to the conveyance and possession, but in all cases the judgment obliger shall have the entire period of 1 year from the date of the registration of the sale to redeem the property. The deed shall be executed by the officer making the sale or by his successor in office, and in the latter case shall have the same validity as though the officer making the sale had continued in office and executed it. Upon the expiration of the right of redemption, the purchaser or redemptioner shall be substituted to and acquire all the rights, title, interest and claim of the judgment obliger to the property as of the time of the levy. The possession of the property shall be given to the purchaser or last redemptioner by the same officer unless a third party adversely to the judgment obliger. 35a. Section 34. Recovery of price if sale not effective, revival of judgment. If the purchaser of real property sold on execution, or his successor in interest, fails to recover the possession thereof, or is evicted therefrom, in consequence of irregularities in the proceedings concerning the sale, or because the judgment has been reversed or set aside, or because the property sold was exempt from execution, or because a third person has vindicated his claim to the property, he may on motion in the same action or in a separate action recover from the judgment. Oblige the price paid, with interest, or so much thereof as has not been delivered to the judgment obliger, or he may, on motion, have the original judgment revived in his name for the whole price with interest, or so much thereof as has been delivered to the judgment obliger. The judgment so revived shall have the same force and effect as an original judgment would have as of the date of the revival and no more. 36a. Section 35. Right to contribution or reimbursement. When property liable to an execution against several persons is sold thereon, and more than a due proportion of the judgment is satisfied out of the proceeds of the sale of the property of one of them, or one of them pays, without a sale, more than his proportion, he may compel a contribution from the others, and when a judgment is upon an obligation of one of them, as security for another, and the surety pays the amount, or any part thereof, either by sale of his property or before sale, he may compel repayment from the principal. 37a. Section 36. Examination of judgment obliger when judgment unsatisfied. When the return of a writ of execution issued against property of a judgment obliger, or any one of several obligers in the same judgment, shows that the judgment remains unsatisfied, in whole or in part, the judgment obligee, at any time after such return is made, shall be entitled to an order from the court which rendered the said judgment, requiring such judgment obliger to appear and be examined concerning his property and income before such court or before a commissioner appointed by it at a specified time and place, and proceedings may thereupon be had for the application of the property and income of the judgment obliger towards the satisfaction of the judgment. But no judgment obliger shall be so required to appear before a court or commissioner outside the province or city in which such obliger resides or is found. 38a. Section 37. Examination of obliger of judgment obliger. When the return of a writ of execution against the property of a judgment obliger shows that the judgment remain unsatisfied, in whole or in part, and upon proof to the satisfaction of the court which issued the writ, that a person, corporation, or other juridical entity has property of such judgment obliger or is indebted to him, the court may, by an order, require such person, corporation, or other juridical entity, or any officer, or member thereof, to appear before the court or a commissioner appointed by it, at a time and place within the province or city where such debtor resides or is found, and be examined concerning the same. The service of the order shall bind all credits due the judgment obliger and all money and property of the judgment obliger in the possession or in the control of such person, corporation, or juridical entity from the time of service, and the court may also require notice of such proceedings to be given to any party to the action in such manner as it may deem proper. 39a. Section 38. Enforcement of attendance and conduct of examination. A party or other person may be compelled, by an order or subpoena, to attend before the court or commissioner to testify as provided in the two preceding sections, and upon failure to obey such order or subpoena or to be sworn, or to answer as a witness or to subscribe his deposition, may be punished for contempt as in other cases. Examinations shall not be unduly prolonged, but the proceedings may be adjourned from time to time, until they are completed. If the examination is before a commissioner, he must take it in writing and certify it to the court. All examinations and answers before a court commissioner must be under oath, and when a corporation or other juridical entity answers, it must be on the oath of an authorized officer or agent thereof. 40a. Section 39. Obliger may pay execution against obligee. After a writ of execution against property has been issued, a person indebted to the judgment obliger may pay to the sheriff holding the writ of execution the amount of his debt or so much thereof as may be necessary to satisfy the judgment, in the manner prescribed in Section 9 of this rule, and the sheriff's receipt shall be a sufficient discharge for the amount so paid or directed to be credited by the judgment obligee on the execution. 41a. Section 40. Order for application of property and income to satisfaction of judgment. The court may order any property of the judgment obliger, or money due him, not exempt from execution, in the hands of either himself or another person, or of a corporation or other juridical entity, to be applied to the satisfaction of the judgment, subject to any prior rights over such property. If, upon investigation of his current income and expenses, it appears that the earnings of the judgment obliger for his personal services are more than necessary for the support of his family, the court may order that he pay the judgment in fixed monthly installments, and upon his failure to pay any such installment when due without good excuse, may punish him for indirect contempt. 42a. Section 41. Appointment of receiver. The court may appoint a receiver of the property of the judgment obliger, and it may also forbid a transfer or other disposition of, or any interference with, the property of the judgment obliger not exempt from execution. 43a. Section 42. Sale of ascertainable interest of judgment obliger in real estate. If it appears that the judgment obliger has an interest in real estate in the place in which proceedings are had, as mortgager or mortgagee or otherwise, and his interest therein can be ascertained without controversy, the receiver may be ordered to sell and convey such real estate or the interest of the obliger therein, and such sale shall be conducted in all respects in the same manner as is provided for the sale of real estate upon execution, and the proceedings thereon shall be approved by the court before the execution of the deed. 34a. Section 43. Proceedings when indebtedness denied or another person claims the property. If it appears that a person or corporation, alleged to have property of the judgment obliger or to be indebted to him, claims an interest in the property adverse to him or denied the debt, the court may authorize, by an order made to that effect, the judgment obligee to institute an action against such person or corporation for the recovery of such interest or debt, forbid a transfer or other disposition of such interest or debt within 120 days from notice of the order, and may punish disobedience of such order as for contempt. Such order may be modified or vacated at any time by the court which issued it, or by the court in which the action is brought, upon such terms as may be just. 45a. Section 44. Entry of satisfaction of judgment by clerk of court. Satisfaction of a judgment shall be entered by the clerk of court in the court docket, and in the execution book, upon the return of a writ of execution showing the full satisfaction of the judgment, or upon the filing of an admission to the satisfaction of the judgment executed and acknowledged in the same manner as a conveyance of real property by the judgment obligee or by his counsel unless a revocation of his authority is filed, or upon the endorsement of such admission by the judgment obligee or his counsel, on the face of the record of the judgment. 46a. Section 45. Entry of satisfaction with or without admission. Whenever a judgment is satisfied in fact, or otherwise than upon an execution on demand of the judgment obliger, the judgment obligee or his counsel must execute and acknowledge, or endorse an admission of the satisfaction as provided in the last preceding section, and after notice and upon motion the court may order either the judgment obligee or his counsel to do so, or may order the entry of satisfaction to be made without such admission. 47a. Section 46. When principal bound by judgment against surety. When a judgment is rendered against a party who stands as surety for another, the latter is also bound from the time that he has notice of the action or proceeding, and an opportunity at the surety's request to join in the defense. 48a. Section 47. Effect of judgments or final orders. The effect of a judgment or final order rendered by a court of the Philippines, having jurisdiction to pronounce the judgment or final order, may be as follows. A. In case of a judgment or final order against a specific thing, or in respect to the probate of a will, or the administration of the estate of a deceased person, or in respect to the personal, political, or legal condition or status of a particular person or his relationship to another, the judgment or final order is conclusive upon the title to the thing, the will or administration or the condition, status, or relationship of the person. However, the probate of a will or granting of letters of administration shall only be prima facie evidence of the death of the testator or inte state. In other cases, the judgment or final order is, with respect to the matter directly adjudged or as to any other matter that could have been missed in relation thereto, conclusive between the parties and their successors in interest, by title subsequent to the commencement of the action or special proceeding, litigating for the same thing and under the same title and in the same capacity, and in any other litigation between the same parties or their successors in interest, that only is deemed to have been adjudged in a former judgment or final order which appears upon its face to have been so adjudged, or which was actually and necessarily included therein or necessary thereto. 49a. Section 48. Effect of foreign judgments or final orders. The effect of a judgment or final order of a tribunal of a foreign country, having jurisdiction to render the judgment or final order is as follows. In case of a judgment or final order upon a specific thing, the judgment or final order is conclusive upon the title to the thing, and in case of a judgment or final order against a person, the judgment or final order is presumptive evidence of a right as between the parties and their successors in interest by a subsequent title. In either case, the judgment or final order may be repelled by evidence of a want of jurisdiction, want of notice to the party, collusion, fraud, or clear mistake of law or fact. 50a.